Hi, I'm Emily Brackstone. I'm a shareholder with Baker Donelson and vice chair of our emerging companies team. For those of you not familiar with Baker Donelson, we are the largest law firm in the Southeast with approximately 700 attorneys across 20 offices in our footprint. Our emerging companies team is a group of lawyers from various practice groups focusing on issues affecting startups. Those details will be provided to you separately. Also note that if you are already operating through an entity, some of the corporate formation documents will not apply to you. With that, I'll turn it over to my colleague, Macaulay Williams, to get started.
Hi, I'm Macaulay Williams, and I'm a corporate attorney with Baker Donelson. Today I'm going to discuss 5 documents. We're going to go over the written consent of the Incorporator, the written consent of the Board of Directors, the written consent of the stockholders, the Certificate of Incorporation, and the Bylaws. The written consent of the Incorporator. An attorney from Baker Donelson will serve as the Incorporator. He or she will then file the Certificate of Incorporation with the Delaware Secretary of State. Also in this document, there will be the appointment of the Board of Directors. In the written consent of the stockholders will approve the equity incentive plan. The Certificate of Incorporation is like the birth certificate of the company. It is filed with the Delaware Secretary of State. It also goes over the number of authorized and issued shares. The authorized shares are the number of shares the company is legally allowed to issue. The issued shares are the number of shares the company actually issues. Here, each company will be authorized to issue 5 million shares. Each company will issue 950,000 shares with a 50,000 share reserve. The bylaws of the corporation is the corporate governance document. In the bylaws, you will find such things as the procedure for the meeting of the stockholders, the meeting for directors, and the powers that the directors and the officers have and such other corporate governance measures. In the written consent of the Board of Directors, the board will approve the actions by the Incorporator. The board will also approve the Certificate of Incorporation, the bylaws. The board will appoint the officers, adopt a fiscal year, and authorize the bank account and the federal EIN number, which is like the corporate Social Security number. The board will approve the sale of common stock. The board will approve the SAFE agreements. The board will also approve the expansion of the board with an investor representative. Finally, the board will approve the equity incentive plan.
Hi, my name is Bill O'Connor, and I'm a corporate attorney at Baker Donelson, and I'm here today to discuss the employee contractor agreement and assignment of rights, the founder restricted common stock purchase agreement, the equity incentive plan, and the written consent of the stockholders. The employee contractor agreement and assignment of rights is an agreement that each founder is going to sign, and it essentially assigns all of the intellectual property to the company. The employer contractor is also agreeing to follow company policies and return any company property to the company upon their termination or resignation. The company's proprietary information is confidential, and any confidential or sensitive company information the employee must keep confidential and not use or disclose to an unauthorized third party or in an unauthorized manner. While the employer contractor is working for the company or for a 1-year period following their termination or resignation, the employer contractor is agreeing to not solicit any of the company's customers or any of their prospective customers, and also the person is agreeing not to solicit any of the company's employees to leave the company or interfere with any of the company's business relationships. The employee contractor agreement also contains an Exhibit A that each founder needs to initial in the appropriate spot. There are 3 choices on Exhibit A. The first choice indicates that the employer contractor is not subject to a restrictive agreement, such as a confidentiality agreement or a non-disclosure agreement. The second choice is that the employer contractor is subject to a restrictive agreement, but that restrictive agreement is not reasonably related to the services they're providing to the company. The third option indicates that the employer contractor is subject to a restrictive agreement and that it is related to the services that are being provided to the company. And if that is applicable, then there's space on the exhibit that we ask that each employer contractor describe the nature of the restrictive agreement without disclosing any confidential information. We also want to point out that this agreement's not just for founders. When the company decides to hire employees or contractors in the future, they need to get each of these people to sign one of these agreements in order to protect the company's interests. The Founder Restricted Common Stock Purchase Agreement is the mechanism by which the founders are issued their shares of the company's common stock. Each individual agreement will indicate how many shares the founder is receiving and the purchase price that the founder is paying for that. At the time that the agreements are signed, the value of the shares is nominal, so the purchase price will be nominal. The shares are issued pursuant to an exemption to federal and state securities laws. so there are transfer restrictions on the shares. The stock certificates will have a legend on the back of it indicating that they're subject to these transfer restrictions. This agreement is also the agreement that addresses the vesting restrictions on the founder's shares. The company has the right to repurchase the founder's shares at the original purchase price subject to a vesting schedule. The vesting schedule is as follows. 1/3 of the shares vest after 1 year. The remaining 2/3 of the shares vest monthly over the following 2 years, such that the founder will be fully vested after a 3-year period. The shares may also vest if there's an acceleration event. There's a double trigger on the acceleration event, and what that means is that 50% of the shares will vest upon the occurrence of a corporate transaction, which would be a merger, a sale of the company, or a change of control of the company. And then any remaining shares that are unvested would vest if, within the 2-year period following the corporate transaction, the employee is terminated without cause or the employee terminates their employment for good reason. The reason that we have this double trigger event instead of having all of the unvested shares vest upon the acceleration event is to alleviate the fear that key management or personnel may leave following the corporate transaction. So by leaving vesting in place for some of the shares, it provides an incentive for these key personnel to stay involved in the company after the transaction. Another important aspect related to the founder restricted common stock purchase agreement is what's known as the 83B election. When shares are subject to vesting restrictions, the excess of fair market value over the purchase price on the date such restrictions lapse is reported as ordinary income and therefore taxed at a higher rate than capital gains. To avoid this adverse tax consequence, the purchaser can elect to be taxed at the time of purchase instead of when the restrictions lapse. This is done by filing an 83B election with the IRS within 30 days after the date of purchase. Because this is such a critical issue to founders, we'll be providing more details on this when the Accelerator kicks off. This agreement also contains an exhibit that each founder needs to sign. It's called the Assignment Separate From Certificate, and what this does is allows the company, if it exercises its repurchase right, to be able to transfer the shares without having to obtain the purchaser's signature at that time. The Equity Incentive Plan provides the framework and rules regarding issuing stock awards to employees, contractors, advisors, and people like that. It's done in order to provide incentives, to reward outstanding work effort, to provide compensation. At the outset, there are 50,000 shares reserved for stock awards pursuant to the plan. The Board of Directors, by default, administers the plan. So the Board of Directors will set the fair market value of the shares when the awards are issued. They will determine vesting restrictions and things of that nature. The plan does provide that the board can set up a plan committee and an awards committee if the board chooses to do so. The type of stock awards that can be issued under the plan are options and restricted stock. Options allow the holder to purchase shares of stock at a certain exercise price within a certain period of time. Restricted stock allows the purchaser to receive stock subject to restrictions such as vesting that would occur over time. The plan also provides the company with the right of first refusal if the participant decides that they want to transfer their shares. The plan also requires that the participant participate in a voting agreement or stockholder agreement or agreement of that nature if the company asks them to do so. The written consent of the stockholders approves the equity incentive plan and approves reserving 50,000 shares of stock to be set aside for issuance of stock awards under the plan.
We are proud to have supported all of the Memphis Accelerators since their inception, and while we are representing the investors in this transaction, our hope is that you will come to know and love us just as much as they do. We will provide different presentations and one-on-one legal office hours throughout the course of the program, so this is certainly not the last you will see of us. The purpose of this video is to provide a high-level overview of the various documents that you'll be asked to sign in connection with the Accelerator. Since this is a general video being used for all of the Memphis Accelerators, we will not get into the specific investment terms of your particular accelerator, but instead are providing a high-level overview. The SAFE, or Simple Agreement for Future Equity, is the investment vehicle for the accelerators. The investors will not receive stock in your company at this time, but instead the right to receive stock in connection with the future funding event. It is like a convertible note in many ways, except there is no stated term or maturity date, nor does it bear interest. Depending on the accelerator that you're participating in, the investors will receive either 2 or 3 SAFEs total. you will see that some of the safes will convert into a fixed percentage of ownership in your company. So in connection with the future funding round, those investors will receive a fixed percentage. Some of the safes convert based on the price per share paid by the investors in the funding round, as opposed to a fixed percentage. These safes contain a valuation cap, so that the price per share at which the safe converts will be the lesser of the price paid by the investors or the price calculated using the valuation cap. The specific terms of the safes will be communicated to you separately. The investor rights agreement grants certain basic rights to the investors, most notably the ability to appoint a director to your board of directors. In addition, it entitles the investors to certain basic financial information about your company. Finally, the signatory authorization form authorizes us to make a Form D securities filing on your behalf in connection with the investment. This concludes our discussion of the Accelerator documents. Please feel free to reach out if you have any questions. We look forward to working with you.